Okay, Kristen, I think what we'll do is that we'll just start the presentation and we'll take it from there. Okay.
Okay, wonderful. I'm going to go ahead and mute everybody, and the recording has begun.
Okay. Well, thank you everybody for attending. We're going to be talking today about the estate planning webinar. It's nice to meet you and over this pandemic, and we're going to be talking about this. So as I mentioned, so there's these Zoom meeting participant controls. So, you know, you can actually go into the chat room and then, you know, send a question if you have. And as I said earlier, if you don't want to do that, you can save your questions to the end, okay? So, why are you here? Is it because you need some estate planning for yourself? Are you, your partner, spouse? Are you concerned about your children, grandchildren, or even worried about, you know, say your mother and father? Also, why are we here? Because what we're trying to protect, are we trying to protect our hard-earned assets that we've worked through our life to, you know, accumulate, or do we have some family businesses? And, you know, one of the things that we're going to be talking about is, I think the most important, you know, documents that we'll talk about are the power of attorneys, because, you know, I'm more worried about you, you know, while you're still alive. You know, what happens if I get sick? And also, you know, obviously we're concerned, what happens after you die? What happens to your assets? Sometimes we want to be in control. Sometimes we can, you know, as I say, control from the grave. Why do I say that? Well, unfortunately, some of our, you know, clients have, you know, children with some problems with opioids, drugs, alcohol. We don't like our daughter-in-law. We don't want our daughter-in-law to get all the money. So there's different things that we can do, basically controlling the grave. So even if we pass on, we're no longer here, we can put stipulations into the wills or trusts, you know, to control what's going on. And what we find is that once we get all the documents done, you know, our clients have, you know, peace of mind. It's like, whew, thank goodness I've got all this done. And so you can start enjoying life. So what we're going to be talking about today is some legal documents, obviously power of attorneys. There's two powers of attorney that we're going to talk about, financial and also healthcare. And including in the healthcare is the living will that most people know, you know, as a living will, but sometimes we call it advance directive or medical directive. So if you hear these terms, it just means a living will. And also we'll talk about a last will and testament, and we'll talk about some trusts. So that's what we're going to be talking about today. We can also talk about organization, beneficiary designations, because sometimes that can avoid, you know, going through what we call probate, etc. And we'll talk about that. But most important, you know, we really go, for you guys, you have to come up with a comprehensive plan. And that's what we're going to be talking about. What does your plan consist of? Is it just power of attorneys and a will, or is it a trust? Is it a special needs trust, irrevocable trust, revocable trust? So we'll talk about those. So to me, what is the most important estate planning document? The most important estate planning document is a power of attorney. As I said, you know, there's two types of power of attorney, financial and medical. But what is a power of attorney? Basically, it's a written document where one person, i.e. me, authorizes another person, say my spouse, to act on my behalf. So if I get sick and I can't make decisions for myself, my wife will basically step into my shoes. And if she can't do it, maybe it's going to be one of the kids or whomever I choose. So why is this really important? Because most of us think, well, our spouse, you know, we're married or I have a partner and they can make decisions for me. Well, they can't. Your spouse has no authority to act on your behalf, whether it's medically or financially. Now, for financially, if you have a joint account, a joint checking savings, then they can access that. However, if you have a 401k, IRAs, or any financial institutions with just your name on it, your spouse can't call them up and get any of that money because they won't even talk to you because you have no authority. Likewise, I don't know if you remember, many years ago, there was the Terry Schiavo case down in Florida, and then it had to go all the way to the Supreme Court because, the husband said, she told him that she wanted to do X, and her parents were saying, no, no, she wanted to do Y. But if she had an advance directive, a living will, or even a healthcare power of attorney, that wouldn't be necessary. So I don't know how much it costs to go to the Supreme Court, but I would imagine it costs an awful lot of money, because the issue would be is if you do not have those documents, then we have to go through a guardianship. And you don't want to go through a guardianship. There's two types of guardianship. One's guardian of the person, dealing with your health and welfare. The other one's guardian of your property, dealing with all of your finances. So if I do not have a power of attorney and I'm incapable of making any decisions for myself, then my spouse would have to file, or the children, or whomever would file a guardianship petition in the circuit court. And unfortunately, it's costly. It usually takes about 3 months. Attorney's fees, I've seen attorney's fees go up to $100,000. Why? Because it becomes contested. And, even the fees are ongoing. Every year, you've got to do a report to the court about, what money you've spent, or if you need specific drugs. So if I need psychotic drugs, or prescription drugs or something like this, sometimes I've got to go in front of a judge to get their approval. Now, I don't know about you, but I don't want a person with a black robe sitting there who doesn't know me making decisions for me. So that's why, we have to have power of attorneys, because if we have power of attorneys, we do not have to go through this guardianship proceeding. So as we talked about, there's two types of power of attorney: financial and healthcare. So what is the financial power of attorney? Well, that allows your, whoever I appoint as my power of attorney, basically to step in my shoes. So anything that I can do, they can do for me. They can open and close bank accounts. They can sell property, defend me in litigation. God forbid I was in a car accident or something, and I need to hire one of those personal injury attorneys. I'm dealing with insurance, canceling insurance, taking more insurance out. So the easiest thing about it is anything I can do, they can do for me. So a lot of times that we see power of attorneys, and they're not, they've got the basic power of attorneys, but for what we do down the road, and we'll talk about this, with trying to save your assets from the nursing home. Within that financial power of attorney, there's got to be certain paragraphs in there, and sometimes they're not there. So one is, if you don't have a financial power of attorney, you need to get it. And if you do have a financial power of attorney, I need you to review it, because there's got to be what we call a gifting provision. The gifting provision is allowing your power of attorney to take your money away from you and give it to someone else. And that, because if we can do that, then we can protect your assets from the nursing home. We also find that we need financial power of attorneys to set up some what we call irrevocable trusts, and we'll talk about that in a little while. But with an irrevocable trust, you can protect your assets from the nursing home, or even creating what we call special needs trusts. So if you have a, a grandchild or a child with supplemental needs, autism, etc., we can create up trust for them to protect their assets and also protect their, healthcare needs through the government program. And also dealing with digital assets, dealing with, banks, etc., because a lot of us have, online banking, or even dealing with social media, whether it's Facebook, LinkedIn, all those type of things. So we need our power of attorney to be able to go in there and talk to these companies, because otherwise they will not talk to you. So, as I say, the financial power of attorney is very, very important, just like the healthcare power of attorney. So, what can the healthcare power of attorney do? Well, it authorizes my agent make medical decisions for me. Consent to surgery, admit or discharge me from a hospital, review my medical records, and be able to talk to healthcare professionals. So, once again, if you think, if I'm out of it, I'm incompetent, then my agent steps in my shoes to talk to doctors, nurses, home care agencies, review all my medical files to consider whether we should go through surgery or not go through surgery, or, hey, I don't like this hospital and I don't like the doctor. So I want to move, my agent wants to move me to another hospital because they will, it's like moving from a local hospital down to Johns Hopkins or University of Maryland, where they feel more confident about what's going on. So that's the healthcare power of attorney. Now, some attorneys do the living will, the advance directive, as a separate document, but we include it in our healthcare power of attorney. So within our healthcare power of attorney is the appointment of the agent and also the advance directive living will. So what is a living will advance directive? Well, it's basically written healthcare instructions regarding your end of life, or if you're in a vegetative state, terminal condition. So if I'm in a coma, or I've got cancer and I'm getting towards the end of life, what I'm saying is, or not saying, don't hook me up to machines. Just let me go. However, I do want what we call comfort care. So give me anything, any pains, prescription, to avoid pain. Give me some prescription drugs to alleviate any pain or suffering. So that's what comfort care is. Sometimes we call it palliative care, and that's basically what hospice is. Hospice can provide care for you towards the end of your life. So, regarding the living will, why would you want, to put your instructions down towards your end of life? Well, sometimes, when we're in, towards that terminal condition, end of life, our families get involved. And, Billy says, well, I talked to Dad and he said, I wanted to do this. And Mary said, well, I talked to Dad and he wanted to do that. And you don't want to get into that, problem between black and white, or, or whatever. So you're putting these instructions down. So it's clear what your needs and wants are, regarding pain relieving drugs, hydration, life prolonging procedures, in artificial nutrition, i.e. feeding tubes, etc. So that's the big thing regarding power of attorneys, your healthcare and your financial power of attorney. Now, who should be your agent? And this becomes a problem sometimes. For most people, they usually appoint their spouse. But, what happens if my spouse has dementia or, Parkinson's or something? Well, maybe it's not a good idea to have them. So maybe we're going to put, a child. So who's the most responsible child? Is it the oldest child? Is it the youngest child? Is it a local child? Because, most of us have families and we're spread all over the United States or even the world. So, if you're having a healthcare agent, my advice is try and have a local child as long as they're competent. Okay, because then, if you have your healthcare agent in Australia, well, I don't know what the time difference is, but it might be 14-hour difference or whatever. And then, it's kind of hard for them to get to the local hospital to make decisions or call in or whatever. A lot of people, well, I've got 3 kids, now I'll make all 3 of them my healthcare and financial power of attorney. Well, that's great, but do they all agree? Okay, sometimes children are like oil and water. They just don't mix. Or what happens if 2 say we want to do X and 1 says Y? I prefer just having 1 agent. Now that agent then can talk to the other children, but at least you're having 1 person making a decision for you. And then that's the person that you trust. Now, let's say that you have 1 child who is a CPA and 1 child, is a nurse. Well, it might be, good for the CPA to be the financial power of attorney and the nurse being the healthcare power of attorney. So you can have, different people doing different jobs, or you can combine them. So for most people, they usually have, 1 child being their financial power of attorney and medical power of attorney. And also, what we want to do is have successor agents. So God forbid something happened to your agent, they couldn't do this anymore for whatever reason, then you want a successor agent to take their position. So who should be your agent? Someone who's trusted, responsible, and skilled. That's basically it. You need someone that you can trust who's going to look after you and be responsible with your assets. So if you have a child who's been in foreclosure, blackmail, is not good with money, I don't think you want to have them look after your finances, okay? So, as I said, if you don't have a power of attorney, you need to get one. If you do, you really need to review your power of attorneys because you've got to make sure they're in compliance with the law. Because Maryland, a few years ago, changed the code, Maryland code. It used to be financial institutions didn't have to recognize power of attorneys. They say, well, don't recognize this. You've got to use ours. So you might have a power of attorney with PNC, Edward Jones, Bank of America. And Maryland said, hey, that's crazy. That's crazy, So they said, as long as this power of attorney, this financial power of attorney meets Maryland code, the financial institutions have to recognize it. So if your power of attorney is more than 5 years old, I would be looking to update those. Obviously, you want to ensure your agent has the power to achieve your goals, whether it's medical or financial. Verify that you've named successor agents, i.e. what happens if my wife as my agent dies or can't do it anymore? Who is going to be my agent? Well, I appointed my brother, Johnny. However, Johnny now has dementia. Do I want Johnny being my successor agent? No. So I'm probably going to have to change, my power of attorney because I don't want Johnny making decisions for me. And that's what we were saying, verify that everybody are still the best agents. Because sometimes, we had a client and she was, what age was she? Like 97. And I was going through the power of attorney, and the power of attorney was done in whatever it was like 1960, 1970. And we're going through, well, your agent is Bob. Well, he's dead. And well, your successor is Dorothy. Well, she passed away. And then it was Mary. Now she's passed away. So basically you had a piece of paper because there was no one alive. So you got to make sure these people are alive. Or if you're separated, you've got divorced, make sure your ex-spouse isn't your agent, unless you really want them to be your agent. So that's the power of attorneys. To me, the most important documents because we're dealing with you while you're still alive. make decisions for you while you're still alive. Then we get into the estate planning of what happens when I die. And the first one is what we call a last will and testament. So what is a last will and testament? Well, it's basically written instructions on how your property is distributed upon your death. So we accumulate things as we, as we age, whether it's a house, furnishings, CDs, check accounts, banks, 401ks, IRAs. So what happens upon my death? Who do I want to give that stuff to? As one of my clients, who gets my stuff once I die? Which is very apropos. So are we going to give it to the spouse? Are we going to give it to charities? We're going to give it to kids? So you can make that decision, and we put that in your last will and testament. Now, with a last will and testament, you also designate what we call a personal representative. They are, we used to call them executors, administrators, and basically they administer your estate. So if you think your estate is a little company, they're the manager of the company. So they manage, the personal representative manages your estate to make sure everything is done correctly and based on your wishes. Because part of the last will and testament is you have to go through a process, regarding, probate. So your personal representative takes your will, the original will, and your death certificate down to the Register of Wills, and then they open up an estate, appointing your personal representative, and then you go through the probate process that you have to do what we call inventory reports, accountings, paying creditors, etc. So this can sometimes be very complicated. And usually the probate process usually takes, approximately about a year or more. And then that's when the distribution is made. And then you have to pay court costs and personal representative fees. Sometimes you hire attorneys, and attorneys to go through an estate. They're very, very expensive. So it's a whole process. Also, within your last will and testament, if you have, minor children, you can designate who's going to be your guardian of your minor children. Or if you have special needs children, sometimes you can, designate a guardian for them. So that basically your last will and testament, it's usually kind of a, a simple document. But the problem is the document then has to go through probate. And there's a lot of people want to avoid going through that probate mess. So for most of us, we have what we call I love you wills. So the I love you will is, if I die, I'm going to give everything to my spouse. And if my spouse predeceases me, I'm going to give everything to my children. So I call that I love you will. But there's also sometimes I love you but will. And what do I mean by that? So let's say that my spouse is in the nursing home and she is on Medicaid. So that means that her assets are below $2,500. And I have the check-in, savings, the house. Now, if I have a I love you will and I die, everything then goes to my spouse. So my check-in, savings, house, etc. Everything goes to her. So now she has more than $2,500, and she will be kicked off of Medicaid. And then you have to spend all those assets down below $2,500. Then reapply for Medicaid, and then she goes back on Medicaid again. However, if you do what we call I love you but will, what that means is that we're going to give what we call a spousal share to our, to my wife, to my spouse. So, and then the other remaining share will be placed either in a trust for her benefit, And if she doesn't use all of that money, then it can go to the kids. But with that other trust, the nursing home can't get at it. They might be able to get at some of the money, but they're not going to get all of the money. So that's why I say, I love you, but we're going to withhold some monies for your benefit, but we're not going to give it to the nursing home. And that's what we're talking about here. It's a spousal share, a spousal election. We're not really going to be talking too much about, well, we're not, Medicaid today, medical assistance, asset protection. We'll sort of touch on it, but, we do other webinars on asset protection and Medicaid. That we'll probably be doing one in the new year. So what we were talking about, everything has to go through probate, but that's not correct. Sometimes there's what we call will substitutes, and it depends on the beneficiary designation. So like for life insurance, IRAs, some types of annuities, they have named beneficiary. So I have a life insurance policy. I name my spouse. If my spouse doesn't survive me, then it goes to the kids. So with that particular beneficiary designation, it will not go through the will, because the only thing that goes through the will is anything that is just totally in my name. Okay? So if it's in my name only, then it has to go through this probate process. Even though the IRA or life insurance are in my name, I have a beneficiary designation to someone else, so that money would go to that someone else. Also, we have, sometimes we call payment on death or transfer on death, but basically that's sometimes that if you have a check that you say payable on death. So when I die, it's payable on death to my wife, kids, or whomever I want to give it to. And also then there's obviously with that, there's a joint tenancy. So what do I mean by that? Well, so if I have a checking account or a savings account with me and my wife and I die, my wife owns it. Or if she passed away, I own it because it was a joint tenancy account, okay? And we also have that in real estate as well. For most of us, if we're married or single, that we own the house, but if we're married, we have it through what we call joint tenancy by the entireties. That means that both me and my wife own the house together. If I die, it goes to my wife. If my wife dies, it goes, to me. So that's the joint tenancy, okay? Versus what we call tenancy in common. This is where it gets a little complicated. So let's say me and my wife have own a home, we've got it in tenancy in common. So that means I own half a house, she owns half a house. So if I die and my will says I'm giving any of my property not to my wife but to my kids, then the kids would get half the house and my wife would have half the house, okay? So that's the tenancy in common. Usually we don't really do that very often. I actually have a personal story that my mother-in-law received an inheritance for some property down in DC. She got, I think it was a 1/250th share of the property. She got like $50. Why did that happen? Well, because it was all in tenancy in common. So way back in the early 1900s, there was 5 kids. So they got it, and then they died, and they gave it to their kids, and then their kids died, and then they gave it to, the other kids. So it was like a big triangle. So then, each kid, 3rd, 4th generation, got whatever there was, and it was like, see, 250 kids. So $100,000, property was done by, 250 people. So sometimes it can get complicated. Okay. So what's our comprehensive plan? What's a comprehensive estate planning? One is, we're looking at short-term disability. What do I mean by that? Well, I get sick. So I'm going into the hospital for rehab. I fall, break my hip. I can't make decisions. I can't pay my bills. So then that's where we need these power of attorneys. Okay. So our power of attorneys can pay our bills, financial power of attorney, or make medical decisions, our healthcare power of attorney. Then also we're planning for long-term care. What happens if I get sick and have to go into the nursing home? How can I protect my assets? We're just, as I say, we're just going to touch on this a little bit here today. And then planning for, what happens when I die. Okay? So we're sort of looking at basically into two components: what happens if I'm sick and what happens if I die. Some people say, well, the easiest thing is to transfer everything to my children. We get this asked all the time. Well, can't I just put, my kid's name on the deed to the house or on my kids' accounts? Well, for me, I don't really like doing that, because what happens if the child gets divorced? If you transfer, your property to your children, all of a sudden your son-in-law or daughter-in-law might, although you might like them, they might be going after some of your property. Maybe you don't like them anymore. What happens if their debts and creditors are coming after your property? They're coming after your accounts. What happens if they become sick and end up going into a nursing home? The nursing home is going to go after your assets. Or what happens if they die? And they die and then they give it to your son-in-law, daughter-in-law, or children. And then you need that money. And unfortunately, then it's gone. So we do not like, transferring everything to our children outright, definitely not outright, or even making them join on our deeds, etc., or accounts. Because if they say, well, I need access to your funds to pay for your funeral, to pay for your medical care, etc. Well, that's why we have the power of attorney, because we want to control everything. So how do we do that? Well, that's the introduction to trust. So we've done what we call the last will and testament. So your last will and testament is just, most of the time, is a simple document saying what happens when we die. Same thing with the trust, what happens to we die, but it's a lot more complicated. So think about, there's numerous types of trusts, high-end trusts, etc. Now, there's basically three trusts that we're going to be talking about. One is what we call a revocable trust, an irrevocable trust, and a special needs trust. We'll talk about that in more detail. But I'm basically just sort of giving you a big overview, an introduction to trust. So what type of trust do you need? It's like buying a car, Do we need a Ferrari, or do we need a truck, or do we need a minivan? Because, it just depends what our needs are. So exploring the types of trust, is the vehicle, as we talked about. What are your objectives? Is there taxes? Are you worried about your children not being able to take care of themselves because of drugs, alcohol, or whatever? Do we have to put some sort of controls over them? What's the circumstance? What's your kid's circumstances? Do you want to leave, everything to charities or whatever? So that's the type of trusted vehicle. So now we have to fund the trust. How do we fund the trust? Well, with financial assets, the real estate. That's why, my analysis or analogy is the gas. You got to fill the gas into the car to make the car go. And how does the car go? With a driver. Well, to drive the car, you are basically the trustee of the trust. You're the manager of the trust. So hopefully that explains, maybe I make it too complicated, but that's what we're trying to do. So common objectives for establishing trust. One is, a lot of our clients do not want to go through probate. So they do not have a will that forces them through probate. A lot of times people come into our office and say, hey, I don't have to go through probate because I have a will. Well, the will drives you into probate. Or if you don't have any estate planning documents, then you die, then you're going to go through probate as well. So how do we avoid probate is by doing what we call a revocable trust. Another objective is long-term care protection. How can we, if we go into a nursing home, how can we protect our assets from the nursing home? There's two types of what we call long-term care protection. One is a crisis plan, i.e. I'm going into the nursing home tomorrow, and one is pre-crisis. And the pre-crisis is utilizing trusts. Sometimes we want to control gifting. As we say that, you know, if we have a child who can't look after their money, maybe we want to give some of the money every month for the rest of their life. Maybe we say, hey, you get a quarter of my money at 25, a quarter at 35, 45, and then you get the remainder at 55. So once again, you know, we can do certain things. Exposure to federal tax. 100% of my clients don't have to worry about federal estate tax, because if you are married, it's over, you've got to have an estate over $22 million. So if you hear about federal estate tax or death tax, for me, I don't get involved in that high-end stuff. So if you come to me and you get more than $22 million, I think that's great, wonderful, congratulations, but I can't help you. I would have to send you to someone else. And then sometimes if we have children or grandchildren with supplemental needs, that's where we do what we call a supplemental needs trust that we'll talk about. And the whole idea of that is to protect the assets, you know, for your child or grandchild. And also, you know, you can manage your assets upon your death. So the trustee could hire, you know, a financial advisor to, you know, to invest your funds. So that's what we're going to be talking about. The three trusts that we utilize in this office are revocable trusts, irrevocable trusts, and special needs trusts. So what is a revocable trust? Okay, the whole idea of the revocable trust is to avoid probate. A number of people come into our office and say, hey, I've got a trust, I've got a revocable trust. My assets are protected from the nursing home. That is incorrect. The only thing the revocable trust is avoids probate. So how do we avoid probate with a revocable trust? So if you think about the trust as a little business, now we have an owner of the business. Just like that, we have an owner of the trust. So let's say I have a revocable trust. I'm the owner of my trust. So I'm setting up all the rules and regulations, okay? And it's revocable. So I can change it, modify it, or revoke it as need be. So let's say that my child didn't give me a nice Thanksgiving turkey this year. I only got a 7-pound turkey from my child instead of getting the 20 pounds. So I'm all upset with that child. So I can then go into my trust and take him out of the distribution upon my death. However, he finds out about this and gives me a nice Christmas present now. So I can put him back in again. I'm sort of being funny about this, but you know, that's the thing with the revocable trust. So only I, as the owner of the trust, we call me the grantor, can revoke or change this. So if I die or get sick, no one else can change it, okay? But I can change it if I'm still alive and capable of making decisions for myself. Now, with the revocable trust, just like the business, business has managers. And then, just like that, then, same with the trust. So the manager of the trust is the trustee. So if with the revocable trust, my revocable trust, I'm the owner, and I'm also going to be the trustee. And likewise, with a business, you have shareholders or beneficiaries. I'm the beneficiary of the trust, while I'm still alive. Now, if I get sick, we have alternate trustees, to run the trust for my benefit. Now, if I die, then that trustee, successor, alternate trustee, takes the trustee's position and then follows my wishes of what's going to happen with my property inside of the trust. So if I have a house, checking account, and savings account in the trust, then all of that would then go to my beneficiaries. And the trustee does that. So the beauty of the revocable trust is when I die, the revocable trust should own all of my properties, assets, house, etc. So when I die, I own nothing, although I own the trust. So there's nothing to probate. So there's nothing to go through the probate process because it's all in the revocable trust. And then the revocable trust can distribute those monies, assets out to the beneficiaries. Or if we've got certain parameters that, we're leaving something $10,000 to our grandchild and the grandchild's, 10, we can hold that money in the trust until that grandchild reached 25. Or as we talked about, if a child has problems with drugs, alcohol, opioids, we don't want to give him $100,000 or her. And then, but then we can stage it every month or at certain parameters or whatever. So it's a flexible document as well. So the only thing the revocable trust is avoids probate. It's not going to protect you from taxes. It doesn't protect you from the nursing home, just avoids probate. So the irrevocable trust that's what we use for a long-term care asset protection planning. So we set up an irrevocable trust. Now you can have both. You can have a revocable trust and an irrevocable, or you can just have an irrevocable, or you can just have a revocable. Now the idea of the irrevocable trust, as I said, is to protect your assets from the nursing home. So like the revocable trust, we're setting up a little business. Now, once again, I am the owner of the business. I am the owner of the trust. So I set up my rules and regulations, who my stuff is going to go to once I die. However, unlike the revocable trust, with the irrevocable trust, I cannot be the trustee. Excuse me. I'm not allowed to be the trustee. So that means I can't go into that trust and change it or grab any monies. So if I can't do that, neither can the nursing home. So the nursing home can't reach in there and grab those assets. Now also, I'm not the beneficiary of the trust. We have to be other people. So basically, once I put assets into this irrevocable trust, I lose control of it. I can't get at it. As I say, if I can't get at it, neither can the nursing home. The only caveat is whenever we put assets into the trust, the irrevocable trust, they have to be there for 5 years to protect them. You might have heard of this Medicaid 5-year look-back period. So that's what happens. So if we apply for Medicaid, the government/nursing home looks back 5 years to see what we've done with the money. So if it's less than 5 years, it's going to be a problem. But if we're home after putting our house and assets after 6 years, so the assets are protected from the nursing home. So that's what we use in our pre-crisis asset protection planning. And the special needs trusts are basically just setting up a trust. So if we have a grandchild who has autism or whatever, and the problem is that we want to leave some money for that, for our grandchild, but if we turn around and give him or her $50,000, he or she will lose our government benefits because they now have more than $2,000. So what we do is we set up a special needs trust, or what sometimes we call it a supplemental needs trust, And we take that $50,000 and put it into the trust for the benefit of that grandchild. But the grandchild can't reach in there and grab it. So basically, it's a non-countable asset as far as the grandchild is concerned. So Medicaid or Medicare don't count that asset against the grandchild, okay? Even though that grandchild, has $50,000 in a trust for their benefit. And we can use that money in that trust for vacations, special beds, scooters, etc. So that's how we do it. So these are the three trusts that we utilize: revocable, irrevocable, and special needs trust here in this office. And that's what, just to recap, revocable versus irrevocable. With a revocable, you've got the ability to amend or revoke the trust. The individual who establishes the trust serves as trustee as well. So irrevocable, basically we're making, potentially making a gift into that trust. Excuse me, I'm sorry. I can't be the trustee or the beneficiary, and we're trying to protect that money from the nursing home. So basically, it's like going from A to B, for most of us. We were just talking about this last night. I don't remember if you remember the AAA, the tickets, that you were trying to go from here to Florida, and you had all this AA stuff and doing all that. Now it's all on the computer through these Waze or whatever. But take it down to Florida, you got a plan. It's the same with your estate planning. What am I trying? What's my goals? What am I trying to accomplish? Can I protect my children from themselves? Can I protect assets from the nursing home? And the answer is yes. And that's basically it. So, what I'm saying here is, really, think about what you want to do and what are your goals. So, Kristen, what I would like to do is just open it up and see if there's any questions. Any questions from the chat room?
Currently, no, we don't have any, but I did ask everyone to unmute if they wanted to speak up, if they had any questions or concerns.
Okay. Anybody, any questions? Well, if there's no questions, I've either done a good job or totally confused you all. So, but what we do is, because you've attended this, we give you what we call an educational credit. That means that you get, we'll reach out to you, and if you want to have a consultation regarding any of this, then we give you that free consultation. Okay. And as we said, that we're recording this, and we will send this to you, so you can listen to it again if you want to, or pass it to your friends or whatever you want to do with it. And then we'll, if you get any questions, please reach out to me, or Kristen will reach out to you to see if we can schedule an appointment if that's what you want to do. But thank you so much, everybody, for attending this. Be safe, and I wish everybody happy holidays. Okay, take care, everybody. Thank you.